Michael Hamad versus, and Louise Mazer versus Charles Hamad? Hamad?
Yeah, yes.
Good morning. Each party will have 15 minutes which to present the case. The appellant may retain up to 5 minutes for rebuttal to the appellant. You want to retain some of that time, let me go and come up to the podium. I'll keep track of the clock and keep you quiet in the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain by the podium as much as possible. We have your briefs and a ready to proceed with the law.
Thank you. May I please report, I'm Tom Lepp here representing the appellant in this case, Charlie Hamad. If I could reserve 5 minutes, I'd appreciate that. I don't think I'll need that though. This is a fairly simple case. This is an estate. Charlie Hamad's father, Charles Hamad, passed away a few years ago, owning a business, Hamad Tire, several stores in the area, and also Mansfield and one in Sandusky. Long and short of it is, at the time of his passing in his will, he wanted Charlie to be the executor. At that time, Charlie, with no experience in this area, obviously retained counsel. He retained Barb Mushcat, local attorney, who had actually written the will, if my memory is correct. There is an interplay, potentially here, of a trust. The problem is, on the record, there is no way to determine what the terms of that trust are and what trust there is. There were several trusts. When you read, there was a hearing back in 2017. During that hearing, there was an acknowledgement that there were several trusts written by Ms. Mushcat on behalf of Charles Hamad. Which one is the one that was actually signed was up in the air as to what was signed and then what the terms of that trust were. There was a hearing about that. There was a hearing in which that issue was raised back in 2017. The judge literally said, I think something to the effect of, this is the trust. There's no ruling on that as to what that means, this is the trust. No one has come forward and said, I mean, there are people who come forward and say this is the trust, but it's not a matter of court record. As a result of that, there was no journal entry. As a result of nothing being journalized, there was nothing to be appealed. As a result of nothing to be appealed, there was no appeal ever taken as to what this is the trust means, be it by Mr. Hamad or by one of his other siblings or someone saying, this is not the proper trust. Long and short of it, though, is this. There was a hearing in 2018. At the hearing in 2018, it was on a motion, it was on objections that was filed by Charlie's sister. Charlie's sister wanted some certain things or objected to certain things that had been filed. One of the things she objected to was an accounting. Another thing she objected to was legal fees that Ms. Mushcat prepared and filed. At the hearing, it became very apparent very quickly that the accounting that was filed and the legal fee documents that were filed with the probate court were false. That they held information in them that was falsified, was not true. During the hearing, the testimony was very clear. Mr. Hamad, being a layperson, not working in the law, not working in the probate court, no true experience, relied on his counsel, Barb Mushcat.
The information that's put on those forms that's filed with the probate court is information that he would know where it came from.
Not necessarily, no. No, what happens when someone probates an estate, and if they don't know, if they're the executor and they're not professional, they don't know what this area is. For example, one of the things that she wrote down was legal fees, that she got paid $8,000 or something or another. He doesn't know at the time that he's signing this that there's something there he needs to review, that she's been paid or not paid. He now knows she was not paid. She represented the court that she was paid. She prepared the document, handed it to him and said, sign this. I have to take this down to the probate court. The same thing with respect to the accounting. In the accounting, she put down information as to Mr. Hamad receiving money, large sum of money. Under oath, Ms. Mushcat indicated we have to do that. That's the only way we can get this to zero out. We found the original inventory with the court. We put X amount of money there. Now monies have been spent, and there's there's money on that inventory, whether it's real inventory, whether that's the proper amount or not, that's still showing. And the only way we can get rid of that money is to show it going out somewhere. So I had it going out to Charlie, and I had it going out to myself. A false accounting, a false legal fee. This is a strange case. I've heard that same argument made several years ago over in Portage County, which was strange because I know Judge Stormer seemed very, very taken aback. And I've heard that same argument in Portage County when a lawyer came in and said, I had to file that. It's the only way I could close out the estate. And when the judge heard that afterwards, there was obviously a referral made. What we're dealing with here is Charlie then gets removed. Charlie gets removed for several reasons. One is obviously there's a false inventory. I mean, not a false inventory, a false accounting. There's a false legal fee. The judge then, what does she do? She strikes the legal fees, she strikes the accounting, we understand that. She also struck the inventory, which is strange. Because now we have a probate court, no inventory has been filed now. So I don't know what's being probated anymore. No one knows. Until someone files that, no one knows. But Charlie should not have been removed. And we believe that the court abused its discretion in removing him. Number one, he relied on counsel. He's not a professional. This is not something he does. He doesn't even work for a bank and a trust or anything of that nature. He relied on a professional. The professional did something that shouldn't have been done, handed it to him, put it in front of him, filed it under his name. That should not have been done. Number two, there was no motion pending at the time. If you look through all the different statutes on removal, there are different statutes on how to remove. There was no motion pending at the time to remove him. It is clear, it is true. When you look at the filing, the objections that was filed by his sister, in the objections, in the middle of the objections, she asked for his removal. First of all, there was not a motion to remove pursuant to the statute. There was no notice of a hearing on the motion to remove given, which is part of the statute. And in her prayer, when you get to the end of the document, she doesn't ask to remove him. So now we're stuck with, okay, what's the basis that the court can remove? Well, what the basis the court can remove is, she can remove on her own in the event of something like maybe he's drunk or something of that nature. There's nothing, no finding has been made. Cannot remove Charlie Hamad as the executor unless and until a proper hearing is held, after a proper motion is filed, and after a proper notice is given. And here, as I said, I think the court abuses discretion anyway. Our second assignment of error goes hand in hand with it, and I do know there are issues out there, and I'm sure this court has found or will find, there are issues as to whether my second assignment of error is final appealable order or not, where it can be appealed. And that is the appointment of Louise Mazer. Louise Mazer is an eminent lawyer in this town. I'm sure all of you know her or are familiar with her. She does excellent work. She should not have been appointed here, though. Once again, the same things that we're arguing about Mr. Hamad apply there. The statutes say there's things you have to do to become appointed. It's not just that the judge says in open court, hey, does everybody here know Louise Mazer? She's a really good person, and everybody agrees she's a good person. The court appoints. You have to file proper paperwork. The proper paperwork has to be served. The proper paperwork has to be served, and notices have to be given. There has to be a hearing set. All those things have to be done. That's what the probate court is. The probate court is, it's not a common law court. It is a court that is created by statute. Its jurisdiction is statutory, and everything it does, practically everything it does, if not everything it does, is statutory in nature. The statutes were not followed. But as I've indicated, there are some cases that say that the removal issue would not be a final appealable issue, or we do believe, I mean not the removal, I mean the appointment, I apologize, the appointment would be, we do believe it is because it goes hand in hand. There is one or two cases that say that. There are other cases that say if you're talking about a bare appointment, good luck, that's probably not a final appealable order. But I think since they go hand in hand here, we do believe that they are. Thank you very much.
May it please the court, my name is Anastasia Wade, and I represent the appellee substitute fiduciary Louise Mazer. The appellees are splitting their time for 15 minutes. I'd like to reserve minutes at the end for Mr. Hobson to argue. This is a case about an executor in two conflicting roles. Charles B. Hamad was the executor of his father's estate and the manager of his father's company, Hamad Tire. As a fiduciary of his father's estate, Charles had a duty to preserve the estate's assets and preserve the interest of the beneficiaries. As the manager of and sole self-appointed sole shareholder of Hamad Tire, Charles had an incentive to increase the business's profits, reduce its expenses, and increase the payout to its shareholder. The two roles diverged when Hamad Tire was required to pay money to the estate, particularly for share distributions and rent. In this scenario, Charles decided to forego his fiduciary duty to the estate for the benefit of Hamad Tire and ultimately himself by placing his own interests above his fiduciary duty as executor. His actions resulted in the estate having claims for monetary damages against Charles. The beneficiaries of the estate directly affected, his brothers and sister, did not want to waive these claims against Charles. As Charles could not prosecute the estate claims himself, his removal as executor was justified and within the probate court's discretion. While Charles' siblings did not want to waive their estate claims against Charles as executor, they also did not want to personally pursue their brother. The probate court ordered the appointment of a disinterested business attorney to take over the affairs of the estate and suggested Louise Major. All of the parties agreed to the appointment of this Major at the hearing, and no party, including Charles Hamad, at the hearing, objected until after the court had approved her appointment. Charles filed an objection to Louise's appointment, but did not file that objection until after the order appointing Louise, which is the order that he appealed. Therefore, there is no argument in this court against Ms. Major's appointment as substitute fiduciary. Charles has challenged his removal as executor and Ms. Major's appointment as substitute fiduciary. His arguments on appeal, however, misunderstand the reasons for his removal and the record on appeal. Charles was removed as executor because the estate had claims against him based on his failure to pay share distributions to the estate and rent to the estate when the shares and the real property on which the rent was due was still within the estate's assets. This breach of Charles' fiduciary duty to the estate resulted in substantial monetary damages to the estate. The evidence supporting these claims is clear from the filings of the probate court and the tax returns of Hamad Tire signed by Charles himself. The appointment of Ms. Major as substitute fiduciary is appropriate because all parties agreed to her appointment, and Charles did not raise any objections that are part of the record on appeal. Thus, any objections to Ms. Major's appointment are waived. For the reasons discussed in our brief, and based on argument here today, the probate court order removing Charles as executor and appointing Ms. Major as substitute fiduciary should be affirmed. Charles was removed as executor because the estate had viable claims against him that its beneficiaries intended to pursue. The claims the estate has against Charles are twofold. First, Charles failed to pay share distributions into the estate while the shares of Hamad Tire were still within the estate's property. The shares of Hamad Tire were ordered distributed to Charles Hamad on August 2016. Prior to that date, the shares were still within the estate. In 2015, according to its tax returns, Hamad Tire had profits of $61,719. In those same tax returns, Charles listed himself as the sole shareholder and distributed the profits entirely to himself. These distributions should have been made to the estate because the estate still held the shares. In 2016, Hamad Tire had profits of $341,289 that were distributed to the shares. None of the profit was distributed to the estate, even though the estate held the shares until August 2016. Charles' failure to pay share distributions to the estate while the estate still held the shares gives the estate a colorable claim against Charles for monetary damages. This alone is enough evidence to justify removing Charles as a fiduciary. The estate's second claim against Charles is for rent Hamad Tire should have paid to the estate while the estate held the property on which Hamad Tire operated. In his reply, Charles appears to misconstrue this claim as a claim of the trust against Hamad Tire. While the trust may have claims against Hamad Tire for failure to pay rent, this is not the issue here. Prior to his death, Hamad Tire paid monthly rent to Charles' father in the amount of $4,211.87 for the use of the two properties. After his father's death, those two properties remained in the estate until they were distributed to the trust on August 19, 2015. In 2014, Hamad Tire's tax returns indicate that Hamad Tire paid rent in the amount of $16,847.48 after Charles' father's death in August 2014.
When that trust, was there anything in the trust until Charles Sr. died?
No, nothing was in the trust,
So
it got
once he
transferred.
passed away, that's when the stuff transferred into the trust?
Correct.
All right.
So, in the 2014 tax returns, we see a payment of $16,847 after August 2014 when Charles' father died. During this time, the real property was still an asset of the estate. None of these payments were accounted for by Charles in the estate accounts. Further, in 2015, Hamad Tire's tax returns reflect that it made no rental payments for its use of the two real properties. The estate was entitled to rent for the properties from January 2015 to August 2015, when the real property was transferred to the estate. Therefore, the estate also has claims against Charles and Hamad Tire for the failure to pay rent while the property was still within the estate's assets. Because the estate has claims against Charles for the missing share distributions and rental payments, there was evidence supporting probate's decision to remove Charles as executor. Therefore, Charles' removal was within the probate court's discretion and should be affirmed. Charles also challenges the appointment of Louise Mazer as substitute fiduciary. As an initial matter, none of Charles' arguments objecting to the appointment of Ms. Mazer are properly before this court. The only orders appealed are the court's March 21st, 2018 order removing Charles as executor, and the court's March 26, 2018 order appointing Ms. Mazer as the new executor. Charles did not file any objections or make any arguments against Ms. Mazer's appointment prior to these orders. In fact, he, through counsel, verbally assented to Ms. Mazer's appointment. Only after the court's order did he file any objections, and the court later ruled on those objections on April 20th, 2018.
Counsel, your argument is obviously that he waived everything, so it's not
Yes.
properly before the court because he waived it.
Correct.
What about if we affirm the first assignment of error? Do you think the court has jurisdiction to look at the second assignment of error?
Well, I think if you affirm this first assignment of error, which is the
Overrule
removal,
it, I should say.
yeah, I think that moves out the second assignment of error.
But do we have, what I'm getting at is something Mr. Leff raised that we have in our notes as well, is the second assignment of error final appeal board. If it was just filed on its own,
Right, it would not be.
I'm
I
just
think,
interested in your opinion on that.
I think there's case law supporting making it a final appeal order with the removal. Additionally, appointments of executors are within the discretion of the probate court, and there is evidence supporting the appointment of Ms. Mazer as the new executor. She was reasonably disinterested in the matter as she is not a beneficiary or a creditor. Also, she is reasonably capable of fulfilling her duties as executor, as she is a well-respected business lawyer in the community. There is evidence supporting Ms. Mazer's appointment as executor, and the probate's order should be affirmed. In conclusion, there is evidence on the record that the estate had claims against Charles, which he, as executor, was unlikely to prosecute. As a result, there is evidence supporting his removal. Ms. Mazer, the substitute fiduciary, was a suitable candidate for executor, as she is disinterested and capable of incapable of handling the estate. I apologize. Thus, there was evidence supporting her appointment as the new executor. Because both of these decisions are within the probate court's discretion, and there is evidence supporting both of these decisions, the probate court's orders removing Charles B. Hamad as executor and appointing Louise Mazer as the new executor should be affirmed. Thank you.
office, and I represent Michael Hamad, one of the beneficiaries of the estate. And I know I only have a couple of minutes, so I just want to touch on a few things. I agree with Mr. Lepp, this is an unusual estate proceeding. Mr. Hamad died back in 2014. The assets in the estate were really pretty simple. He had shares of stock, he had 500 shares of stock in a company, and he had some real estate. I think there may have been a couple of vehicles that were almost meaningless. The will was very clear. The stock was supposed to go to 3 of his sons. All 3 were sons that worked in the company. It made sense. He wanted that stock to go to his 3 sons equally. He had real estate that he wanted to go over to a trust. He had 6 kids in all, and the trust was going to benefit all 6 kids equally. Things went sideways pretty quickly. I refer to him as Charlie. It's how we've referred to him throughout, I guess, Junior. Charlie was made the executor of the estate, and as was alluded to here, also put himself in control of the company. And as a result, I think that's how things kind of got sideways on this. I just want to reiterate that a couple of things. The trust Mr. Lepp refers to, he says there's multiple trusts. I mean, I think that's really just sort of a red herring as to which trust may be applicable. The court did, in fact, hold a hearing on that issue and indicated which trust they believe applied. But the reality of that is the hearing was being held because Mr. Charlie Hamad had filed a motion trying to vacate certain orders that he had previously, or certain certificates of transfer that he had previously filed with the court, moving all that property over to the trust. I mean, sort of got a pattern here that every time he makes a decision and things go in one direction, several months go by and it isn't benefiting him, and he wants to sort of undo and redo those things. We had a whale of a time just getting the stock transferred over to the brothers. It never did happen. Again, 4 years ago he died. The dad did. At the hearing we had in March of 2018, Charlie's still testifying that somehow the stock is all still in the estate. That was his testimony under oath for the court. The court said, fine, if it's in the estate, then you should have been paying money to the estate. Those distributions that you've been reporting on tax returns that Charlie signed show that there was an awful lot of money that was going to you as the sole shareholder. There's also sort of a pattern of blaming others often. I mean, we heard testimony that Charlie was just doing what, argument that Charlie was just doing what his attorney told him to do. The reality of it is he removed Bart Mushkat back in 2017. The hearing we were having on the objections was in March of 2018. He had a whole different attorney at the time. It was over a year had passed. They knew there were objections that had been filed. And sort of the same thing, I guess, with the accountants was that, well, you know, I'm just doing what the accountants told me to do. We think there was lots of evidence in front of Judge Stormer. She knew the history of this case. It's been going on and on and on. And frankly, I think got fed up with it, and I think, frankly, has the authority under the statute. 2 separate provisions that have been referenced here. One of them does require prior notice, 10 days prior notice, the one for neglect, or as the phrase says, that the court can remove a fiduciary because of the interest of the estate, that the fiduciary is responsible for administering demands it. As was referenced, there was a motion that was filed by the sister trustee objecting to things and asking that he be removed. I know it's been presented that it was buried in this motion and whatnot. It was a 2-page motion. I mean, it says in there he should be removed. He's not paying rent to the trust and to the estate that he should have been paying to. And it says, you know, there's self-dealings going on here. That was filed back in January of 2017. This hearing, because of a series of delays and things that kept going on, this hearing occurred in March of 2018. So yes, it was renewed again. Her counsel filed a motion again asking that he be removed at that time. But also in 2313-18A, it simply says that they can be removed because there's unsettled claims between the executor and the estate. There's no prior hearing notice that I'm aware of, but certainly it came as no surprise based on all the proceedings and hearings and filings that were going back and forth that the record all reflects in this case that Mr. Hamad knew what was going on and what was at issue here. And then I guess just to the last point, yes, there was a hearing in open courtroom for a couple of hours. It became clear that Mr. Hamad was going to be removed because of all the self-dealing that was going on, and so a discussion turned with the court toward that issue. And everyone agreed that Attorney Louise Major would make sense to be appointed as a neutral individual. So if there's any other questions, I can try to address those, but I think my counsel has represented things well.
Attorney Left, you have your 5 minutes, so.
Let's just take a moment or two here, very briefly. As we've argued before, and as we're talking about here, we're talking about shared distributions or rent or whatever we're talking about here. The problem is, we didn't have a full hearing on those issues, and there were no findings made on those issues by the judge. The judge started a hearing in March of 2018, and then ceased the hearing in March of 2018. We never got to that issue of what is going on here, what is going on there. What we got to is the issue of Charlie was asked about questions about the accounting, he was asked questions about the legal fee, he stated what he stated, and at some point the judge decided she was going to pull in Attorney Mushkat at that time as the court's own witness and examine her and find out what happened. And then shortly after that, the judge just ceased the hearing and then made her decision. Once again, I am not personally attacking Louise Major, as I'm sure all of you know her. I'm sure everyone in the room knows her. She is an excellent attorney with a very fine, my opinion is very high. I've known Louise for several years. That's not the issue. The issue is that Charlie should not have been removed. He was not removed properly, not with proper notice. He was not removed properly without notice. And there was not a sufficient record for the removal of him. And unless and until that happens, he should not be removed. Unless and until that happens, Louise Major, who would be otherwise competent to take this on, obviously would be, cannot be appointed and should not have been appointed.
Counsel,
Yes.
I'm going to ask you a similar question that I asked opposing counsel, and that is, with your second assignment there, I appreciate the fact that you brought it up because it was in the court's notes as well, so I appreciate that.
Yes.
But if we overrule the first assignment of error, what effect does that have on your second assignment of error?
I don't know the answer to that.
It seems like-
As I've indicated, the cases I found on the issue, if you were just talking about my second assignment of error only, for the most part, seemed to be that it's not a final appeal order. But if you were talking about them together, then it was a final appeal order. I would take the position as a final appeal order. I don't know, though. I was not able to locate, did not see any cases of what if the
It is
first part is
confusing.
not ruled on or ruled on otherwise.
It is confusing, but I was also getting to the point that it seems like you really don't have that big objection to Louise Major. You have an objection to the removal of your client.
The removal of the client is the biggest issue, Your Honor. And obviously, we don't believe that Ms. Mazur should then be stepping in here. Their father chose Charlie. Their father chose Charlie to run this business. Their father chose Charlie to be a 1/3 shareholder. Their father chose Charlie to be the executor. He's not available anymore to tell us why he did all that, but he did that, and that is supposed to be upheld unless there is something extreme that has happened otherwise, and I don't believe we have that here. There is case law that talks about what if there are conflicts. This court, in fact, had a case, I believe it was Meyer was the name of it, in which this court agreed with the probate court saying, no, this doesn't rise to it. The fact that you have a claim, and in fact, you even have a colorable claim, you have to look to other things. In this instance, as I've indicated, that hearing ended abruptly without being even finalized, without even really getting into the meat of the thing, if that's the issue. If that is the issue of the rent, so that's the issue as to the tax returns were filed and all these other things, that was not completely ferreted out. What was ferreted out was that he signed documents that were put in front of him that he was told to sign, which were false and which had fake information in them, that were then filed with the court.
Doesn't he have a fiduciary duty to the estate to know that the document that he's signing is correct?
He does have a fiduciary
Or
duty.
even to ask a question?
He does have a fiduciary duty, yes. But his fiduciary duty, he was discharging it as most people who are not professionals discharge it in this town and most towns, by hiring an attorney who is experienced in the probate court, who says they're experienced in the probate court, who is familiar with the documents and said, this is what we do, this is how we do it. Sign this here and I will file it on your behalf. He made a mistake. Thank you very much.
Thank you. Thank you all for your presentation today. The court will take a matter under advisement and issue a written decision which will be mailed to all sides as well as posted to our website and on the Supreme Court.